Hello and welcome to Indianomics. On the 28th of February, Tata Sons announced it is ending its dispute with NTT Docomo and has agreed to enforce the award announced by the London Court of International Arbitration. The joy was short-lived. 8 days later, the Reserve Bank said it is opposing the consent terms since payment of the agreed amount of $1.17 billion to Docomo will breach the current foreign exchange rules. The court raised two questions to RBI. One, does it have the right to oppose an arbitral award? And two, is it opposing the consent at the behest of the Finance Ministry or autonomously? RBI's reply is awaited. Today we will discuss various legal tangles thrown up in the course of this case. But first, the backstory. In 2009, Docomo bought 26% stake in Tata Teleservices at $2.7 billion. It bought the shares from Tata Power and Tata Communications on the understanding that if the value fell below half the purchase price, Tata Com and Tata Power will have to find new buyers for its shares at a minimum value of $1.17 billion. The shares fell below the protection price and the put option was triggered. Tatas had to find new buyers or pay up. Opposition came from the Reserve Bank. The Reserve Bank and the government have traditionally put no limits on equity investments from foreigners, but have capped debt investments since over-indebted countries often see a run on their currency. But what if equity investors add put options such that their money will automatically be called back if the return on investment fell below, say, 8 or 10%? Reserve Bank disallowed all these assured return products as debt in the guise of equity. However, in 2014, when the Tatas made a request to the Reserve Bank that they pay Docomo, RBI agreed, saying this wasn't an assured return product but a downside protection. However, their recommendation was struck down by the government. A year later, on February 3, 2015, Governor Raghuram Rajan said Reserve Bank will amend rules to allow foreign equity investors to add clauses that assure them a return below the sovereign yield. The promise was never fulfilled. The rules were not changed. This was partly because in the same month, the budget announced that henceforth the government will make old rules on capital account transactions with respect to equities, while the Reserve Bank will make rules on capital account transactions with respect to debt instruments. This clause was passed along with the Finance Act, but was never notified. The FEMA was never amended. Well, that's the story. And joining me now is eminent jurist Dr. Abhishek Manu Singhvi. Dr. Singhvi, thanks much for joining me. First, prima facie, if Docomo wanted half its capital protected, wouldn't it amount to an assured return on an equity instrument? And RBI, as we know, has always opposed assured returns on equity instruments. So does it have a case?
As I said, I am speaking in the capacity of a disinterested observer
Yes.
and a legal person. Not as a participant, so I don't know the exact facts.
Okay.
But let me tell you two or three things. First of all, I think the entire community of industrialists and the business community should applaud the fact that this is a rare occurrence. Let's step back a moment and just see that how rare an occurrence it is that such a large amount has been amicably at least attempted to be settled. Second, to your specific question, I think this case has some very peculiar features which need to be underlined. One is that the RBI doesn't seem to have found, initially at least in a very strange, very detailed recommendation, anything wrong with it. That should be given a lot of weight. Now, the second issue which will arise, which I'm sure lawyers will address in the case, if it goes to that, is that whether that RBI written specific recommendation which you rightly mentioned can at all be overridden by the government. Is there a specific power? Third, you may change the government policy for the future. But when this happened and an RBI gave an understanding, a recommendation, I think there is much weight in the fact that it should be looked into and honored. And lastly, a provision for capital, and this is very important, I think, a provision for capital erosion protection, which is admittedly seen as not collusive or, illegal in that brazen sense. should be seriously considered, because ultimately in the larger policy perspective, it is a huge help to Indians to receive and to encourage investments in India. At the end of the day, the larger story is that people want investments in India. Now, investments in India, especially in top blue chip situations, will increase considerably if these kind of policies are tweaked to specify that these are not held to be illegal merely because you want to protect your capital. You're not asking for rapacious rates of interest. You're not asking for a guaranteed return. You are really saying that, look, I must get a reasonable thing which may be below the sovereign rate, but I should not be losing capital. This is what encourages investment.
Well, there would be several interpretations of both the government and the RBI in several cases, which they would have disagreed. But nevertheless, some weight should also be given to the fact that this is, in a sense, an assured return. No matter what happens to this investment, I should get at least $1.2 billion back. That assured return is not something which the law of the land on that day allowed. Therefore, Dr. Singhvi, yet again, would not the RBI have the right, no matter what the arbitration said, this is not the law of my country, would not every regulator have the right to set aside an arbitration order which was against the law of the land?
Well, I think it is absolutely clear that if an award is judged by the court to be contrary to public policy, not the law of the land, that's a different phrase, but contrary to public policy of India, it would be liable to be set aside. There's no doubt about that. The judge of that will not be the RBI, the judge of that will not be the arbitral panel, and the judge of that will not be the parties. The judge of that will be ultimately the court to which that award is brought for enforcement, in this case the Delhi or whichever court is involved. Number three, that process is under the Arbitration Act, provided in a particular section, which uses the phrase public policy. Now, public policy is not merely law. It has to be law plus. It has to be an egregious violation which affects the underlying basis of the legal system. Now, there I agree with you that it's an open question as to whether the court will go this way or that way, and there is certainly a bona fide strength in the argument of the RBI that this affects Indian public policy, because it's not a case of only Docomo and Tata, but across the board it will affect foreign exchange outflows if people start giving guaranteed returns of this kind. Therefore, I think it's a very important issue for the government to sit back and take a relook. The government should seriously consider modifying this policy and putting caveats which allow such kind of clauses to a limited extent, where A, they are not found collusive, B, they specify a rate below a certain specified rate by the government, C, they are clearly intended to protect your thing. So that would be a much happier solution than doing a case-by-case court adjudication, which is what is going to happen in this case. But as things stand today, yes, there is a 50-50 chance and a strong argument on each side. Interestingly, Docomo and Tata would be on the same side for this argument, and RBI on the other. There's a lot to be said for each side, that this may or may not fall foul of public policy exception, which I happen to appear in all those cases. Was elaborated from as far back as Renu Sagar's case, Renu Sagar and GC, and other judgments of the Supreme Court.
Well, fair enough. Just a final question. You know, the court brought up an issue. Are you doing it on your own will, or is it at the behest of the Finance Ministry? Isn't that a moot point? Is that a relevant point at all? After all, in all countries, capital account and current account transaction rules are made by both in consultation with each other.
No, I think it's a very relevant question from the court. The question is intended to elicit facts and information to suggest whether the parties and the actors consider it genuinely against public policy. Now, suppose you and I have a transaction in which we have this clause, and the RBI makes a recommendation saying, it's okay, you can take this money. It's a clear indication that the RBI does not treat it as a default of public policy. However, subsequently, RBI changes its view. So the court is asking, what made you change your view? Was it government pressure or something else? And did you have sufficient reasons to change that view? That will be a factor in the calculus of deciding whether it affects public policy, which is the only basis on which the RBI can stop it.
In case the Finance Act clause of 2015 had been made into law, then this point would not have risen, because in that case, the government does make all the rules with respect to capital account convertibility on equity instruments.
Well, that is correct, but I mean, that's a vicious for horses if this thing would happen. That would be correct. It would depend on the date of the transaction also, because the 2015 law would normally not have retrospective effect to an earlier transaction. But I don't know the exact dates, but certainly that law for all transactions after 2015 would put a different color had it been made.
Thank you very much, Dr. Singhvi, for sparing your time. Well, we need to take a break. Thereafter, I'm going to be joined by two more legal eagles on the issue, Sandeep Parekh of FinSec Advisors and Vaibhav Parekh of Nishit Desai Associates.